Hi, everyone. Welcome. My name is Chaya Molberg, and I'm the event director for Buildings NY. We're so pleased to have you here today at Buildings NY's Unlocked Educational Session. Today's session is sponsored by the Habitat Group, and I'm very pleased to, in a moment, introduce Heather Stone to you. First, I forgot, I want to give you a little housekeeping. This educational session is being recorded for future on-demand viewing. Anyone who has any question at all can send it through a chat box that you'll see. You won't be able to see anyone else's questions, but we will see all questions and they're connected to your email. So if Heather and Eileen are unable to get to your specific question today, they will have the question and your email address after this webinar in a day or two, and they'll be certain to follow up. With that, thank you all again for participating, and I'm pleased to introduce Heather Stone. She's the executive editor of the Habitat Group. Heather, thank you so much for sponsoring today's session.
Well, thank you, Haya, and thank you to Buildings New York for hosting the program. I am the executive editor of the Habitat Group, and one of our publications is the 2020 Rent Regulation Checklist, and today's speaker is the author of that. And I'd like to introduce you to her right now. Eileen O'Toole is the principal of the Law Office of Eileen O'Toole. She counsels owners, lenders, and prospective purchasers of residential properties on rent regulatory and other housing issues. She also appears before courts and the DHCR in all phases of landlord-tenant litigation. As I said, she's the author of the 2020 Rent Regulation Checklist, a comprehensive guide to rent stabilization and rent control published by the Habitat Group, as well as the forthcoming 2021 edition. She also writes the Habitat Group's monthly case law digest, New York City Landlord v. Tenant, and edits the annual New York City Apartment Management Checklist, a guide to building maintenance laws and regulations. And the first edition of the Rent Regulation Checklist came out in 2019. So the subsequent edition, the 2020 edition, had many changes. And so I'm going to let Eileen take it from here and tell you all about the things you need to know since last year. Thank you, Eileen.
Okay. Thanks, Heather. Hi, everybody. I am going to cover a lot of material today. There is so much material, so many things that changed under the HSTPA, and there have been some changes since then, and there have been some developments in how cases are being processed because of the changes in the law, and then there is the Regina case that we will talk about. But first, I'll just show you the overview of what we'll cover today. And there's so much. Some of it I'm going to try to go through quickly. You know, for the past few months, we've listened to Governor Cuomo talk about New York tough. And I don't know if he ever talked about New York fast. Well, people in New York tend to talk real fast, which we may have to do to get through some of this. But just to let you know, I'm going to probably cover these things in order, but the things that there may be the most to say about at this time have to do with rent overcharge and major capital improvements, because DHCR has just issued some information. And we're also going to talk about non-payment proceedings and holdover proceedings in housing court, because there were changes in the HSTPA to those laws too. It wasn't just the rent stabilization law. And there has been, there are changes, it seems, several times a week now with how housing court is going forward and proceeding and what's happening with eviction moratoriums. And there's really a lot to keep up on, when on the other hand, it felt like, you know, we were all sort of walking through amber for about 3 months and nothing was happening. So with that, I think we can get started. The first thing I'm going to talk about is deregulation. That was it was anticipated, and one of the biggest features of HSTPA, that high rent vacancy deregulation, which had developed over 20 years under rent stabilization and rent control, was eliminated, and high rent, high income deregulation was also eliminated. These things were both eliminated as of June 14th. So if you had an apartment that was lawfully deregulated before June 14th, that apartment remained deregulated. That doesn't mean that a tenant wasn't able to challenge the deregulation still to this day, but the apartment is deregulated if it was lawfully deregulated. But if you had, after June 14th last year, if you had a rent that was very close to the deregulation threshold and a vacancy increase got it over the threshold, you were no longer deregulated. You're still subject to rent stabilization. What has been of a little more interest is how DHCR has processed what they call the LD application since last year. You know, as some of you may know, there's an annual cycle of processing applications that are filed by owners. If the tenant's rent gets up to a certain level and the owner wants to confirm whether the income is above the deregulation thresholds, applications have to be filed with DHCR. In 2019, the due date for the applications was right before HSTPA came out. So what happened over several months after that was DHCR just dismissed all of the 2019 LD applications, high rent, high income deregulation applications. And those, it would be hard to appeal if anyone was considering doing that. The ones that are more problematic, there were LD applications pending for a number of years going back. They were still pending when the law changed. And what happened was, you know, the law said that the LD applications were supposed to be processed very quickly. They actually gave specific number of days that they were supposed to be sent to the tenant, and then answers filed, and DHCR issued decisions. But in fact, in June 2019, there were some LD applications that had been sitting before the DHCR for a year or 2 years or sometimes 3 years or more. And when the law changed, they said this law applies to any pending applications. So DHCR just started terminating them. And the problem with that some owners have filed objections about and have filed appeals on is that you know, if these LD applications weren't decided because of DHCR's long-term delay, is it fair to just dismiss them and not allow the apartments to be deregulated? So there are some cases out there about that. I haven't seen any decisions on that issue so far, but owners who have these cases, a lot of them have raised that as an issue. And I think we can go to the next slide. One of the things that is still coming out from DHCR has been very quiet. They haven't issued much in the last 3 months. But they, even as recently as February, they were issuing orders about these explanatory addenda. What would happen after HSTPA is that if you had an order that said this apartment could get deregulated because the income and the rent are high enough, they would issue a separate explanatory addenda saying that if the order was issued before June 14th, 2019, but the lease in effect on that date wasn't expiring until after June 14th, 2019, you could not be deregulated because the apartment was still rent stabilized until after June 14th, 2019, and then there is no more deregulation, so you don't get deregulated. Owners have filed objections to these. I just saw a DHCR decision, this is on the next slide, I think, Heather, called Matter of Goldsmith, and that where the owner challenged the use of the explanatory addenda to basically dismiss their LD application, and the DHCR has upheld that. And that's something, one of the things I do for Habitat is write their monthly landlord versus tenant case digest. So that's what I was doing the other day, is finishing up this month's issue. So that was a decision that we just saw. I just make a note of what some of the objections are to the termination of the pending LD proceedings that owners have raised in some of their appeals of these. So you might want to take a note of that. Leasing issues, the next thing we may want to talk about. Leasing issues, the DHCR, or excuse me, the HSTPA made a big change to the collection of rent increases upon vacancies. There's no longer any 18 or 20% vacancy increases. And the HSTPA also said that the Rent Guidelines Board couldn't issue vacancy increases. So that kind of raised a question for a lot of people. Well, if you can still have renewal increases under rent guidelines, how can you not have any vacancy increases if you have a vacancy lease? Now, DHCR and the Rent Guidelines Board have said that you can collect renewal increases for vacancy leases. And the current renewal leases, the renewal increases, I believe, are 1.5% for a one-year lease and 2.5% for a two-year lease. But there was a lot of push this year for the new rent guidelines to freeze the rent. So guideline number 52 that goes into effect on October 1st, that just came out last week. And for a one-year renewal lease or vacancy lease, you get a 0% rent increase. And for a two-year lease, this is unusual. They actually split the increase. They said for the first year, you get 0% increase, and for the second year, you get 1% increase. Longevity increases were eliminated under HSTPA. Preferential rent, if you give a tenant a preferential rent, you have to continue that throughout the tenancy of that person, although the rent can revert to the legal rent after that person moves out. So those are some of the things that that came up under HSTPA. Also, HSTPA said that you could no longer collect excessive fees from tenants. You know, if a tenant made an application to rent an apartment, fees were limited to $20. And then there was a lot of back and forth about, well, did this apply to brokers? Because real estate brokers charge much more than $20 to assist renting of the apartments. And there have been some orders that have come down last fall. The state said, yes, this was intended to apply to brokers. And then there was a lawsuit filed earlier this year when that kind of put a stay on limiting the broker's fees. So I don't think there has been a decision on that so far. There have been some changes to security deposits. If you have unregulated apartments, you can only collect 1 month security deposit now, just as with rent stabilized tenants. And there are some new rules added to the security deposit law about giving the tenants the opportunity to look at an apartment before they move in to see if anything needs to get fixed. And when tenants move out, owners now specifically have 14 days to either return the security deposit or tell the tenant why they're not returning the security deposit, and show them how the itemization of what's being withheld. One of the things that became a big issue last year and then nothing happened with it was the good cause eviction bill that everyone was talking about for a long time, that was supposed to require the renewal of unregulated leases. And that was not passed by the legislature last year. There was a lot of concern by owners that it would get passed this year, but that hasn't happened, and probably with everything else going on, that really just is not an issue at this point. One thing I don't have a slide for, but I should mention, is mitigation of damages, because that actually has become an issue in the last few months. The law added by HSTPA said that if a tenant breaks the lease, the owner has the duty to mitigate the damages. So if the tenant moves out and has 6 months left on their lease, by the lease language, they're responsible for the next 6 months of rent. But the landlord has to try to re-rent the apartment. And once they've re-rented the apartment and show they've done that in good faith, the tenant's liability ends. So that's been an issue lately because there are a lot of tenants who have broken leases. There are people who have moved out of New York City, and there are people who have lost jobs and don't have money. And there are just all kinds of scenarios out there. And sometimes there are things going on that this will provide an opportunity for a settlement of issues. I had one case recently where a tenant wanted to break her lease, and she had a pending rent overcharge complaint with DHCR, and she owed a few months' rent. So we were able to resolve all of that in this settlement of the mitigation of damages issue. The other thing that comes up, I'll mention this, this is relevant to the individual apartment increases that we'll talk about later, but one of the things that has been a recurring question by owners with the leasing issues, because the amount of rent increases that you can collect now are so limited, owners have been asking, well, how can I increase the rent? How can I increase the rent? And one of the things that has been talked about is the creation of new apartments where, you have apartment A and apartment B next to each other. They both become vacant. You combine those into a new apartment. And if you have a new apartment, up until now, you have been allowed under rent stabilization procedures and regulations. It's not really even part of the law per se, to set a first rent, whatever the market rent is, but that rent becomes a rent stabilized rent. There was some discussion before COVID that the rent stabilization code, the amended code, would actually have some rules in there about creating new apartments, and we don't know what those will be. And I guess I'll mention at this point, one of the things that HSTPA did was require owners to require owners to, I just lost my train of thought. Well, we'll go back to that. But the HSTPA requires the DHCR, not the owners, the DHCR to amend the rent stabilization code to go with the law by June 30th of this year. Now, DHCR hasn't said anything much about anything in the last few months, let alone the code. So I don't think that there will be code amendments by June 30th because those actually require public hearings before the changes are made. So I think that DHCR has been working on some changes to the code, but I do not anticipate that they're going to be out when they were supposed to be out. So but the people are looking to see what the code is going to have to say about creating new apartments now. Moving on to rent overcharge. Rent overcharge is a big one. Rent overcharge, HSTPA was terrible for owners in terms of rent overcharge. The 4-year look-back period was expanded to 6 years, but the complaint could actually be filed at any time. The 2 years look-back for treble damages was expanded to 6 years. There's no more safe harbor that if you paid back the overcharge after the tenant filed the complaint, you wouldn't get hit with treble damages. And all of these changes were made effective for pending complaints on June 14th, 2019. And one of the problems with that was that there were many rent overcharge complaints pending on June 14th, 2019, because the DHCR had become so slow in processing them. So what happened after HSTPA was that the DHCR started sending notices to owners or their attorneys who had answered overcharge complaints sometimes a year or more previously, and saying, well, you sent us 4 years of rent history information. Now you have to send us another 2 years because we're looking back 6 years. And, a lot of owners that I worked with would answer those requests for additional information, provide the documentation if they had it, but also make a number of objections to doing this. It was a denial of due process. It was unfair. This just shouldn't happen. By the fall, there was a court case that went to the appellate court, Dugan versus London Terrace, which upheld doing this. Dugan was a court case where you had a class action, a number of tenants with overcharge claims, and they hadn't quite figured out how to do the calculations. And then HSTPA happened and said, we're going to have to refigure out how to do the calculations because now we're going back 6 years. So then these issues actually got up to New York's highest court, the Court of Appeals, pretty quickly. By April 1st, there was a decision, and it was like the tree falling in the forest, and no one was there to hear it. There was, because there was so much else going on in terms of, COVID and people being out of their offices and DHCR not issuing anything and the courts being pretty quiet. This Regina Metropolitan versus DHCR decision came down that said, yes, it's wrong to retroactively apply the HSTPA changes to pending cases that were already filed before June 14th, 2019. It was unfair to owners. It denied them due process. There's a lot of language in the decision. The decision itself, there were several judges who dissented. They didn't disagree with the majority decision. So the majority decision is 50 pages long, and then the dissent is another 50 pages long. So there was still a lot of disagreement about this. But Regina was a big deal in landlord-tenant, rent stabilization world. And since then, I guess what's happened, and you see the difference between DHCR and the court, since DHCR has been quiet and it's not clear what operations are functioning, rent registration is functioning, TPU complaints that maybe get filed electronically are functioning, but since most complaints and applications get filed by hand delivery or certified mail to offices that are not open to the public, there hasn't been really much processing, if any, of anything. So now you have all these rent overcharge complaints where the request for 2 more years of information was wrong. You have a number of cases where DHCR issued orders they issued orders before June 14th, 2019 that applied the old rule. Then if the landlord or the tenant filed a PAR that was pending on June 14th, 2019, DHCR reopened all those cases. In January alone, they issued 40 PAR decisions saying, oh, well, now that HSTPA came down, we have to reopen this case and send it back and go back 6 years, not 4 years. And in February, there was another 20 cases. And then before January, there were cases coming down every month. Those decisions are now all wrong. And whether people have filed further appeals of those, or whether they can, how you get the DHCR to reconsider your decision remains to be seen. If you have pending cases, DHCR may on their own start applying Regina, but it probably is in the interest of people who have overcharge cases where this is an issue to file letters to DHCR to point out that, now that the decisions have to be changed. So that's a big deal. The courts, since the Regina case came down, the courts, even though the housing courts were also closed during the past 3 months, the judges in housing courts were actually working. They were, working electronically on some, first it was just essential matters, and then they started to expand it a little to non-essential matters. But if judges had all these cases and where they had to write decisions, it gave judges several months to catch up on their decisions. And judges on their own were applying Regina. So you've started to see a number of court cases. One of them I even just saw recently got up to the appellate division already, where Regina is applied. That, the courts say, yeah, under Regina, we can't go back 6 years on these pending cases. You can only go back 4 years. Now, the new rules still apply to new rent overcharge complaints. So there's going to be some, difference and people having to figure out what's what with each of their cases. But that's been really the biggest news in rent stabilization world in the past few months or so far this year.
Am I on the correct?
I have some other. I'm sorry. Go ahead.
Am I on the correct slide? Go
Yeah,
forward.
a lot of what's in, yeah, I would go for it. What's in the slides here are just some things that you can, oh, the one thing I should mention is the Collazo case. The same day that they decided the Regina case, the Collazo versus Netherlands property case came down from New York's highest court. And Collazo was interesting because it's always been true that if you have a rent overcharge complaint, you can file it with DHCR, or you can go to New York State Supreme Court and file an overcharge complaint, which would cost you a little more or maybe a lot more to do that, but you might get a faster result. And if you have multiple tenants involved, it may be a better way to do something. Or if you were in housing court in a non-payment case, the tenant could say, well, I don't know this rent, I owed a rent overcharge, and the court could consider that. What was happening, though, is that in a lot of cases, the courts were coming to the point where they were saying, not all courts, but some of them were saying, well, this is complicated. I think really the DHCR should decide this case, not the court, because the DHCR has primary jurisdiction. And so, tenant, you've got to start your case all over, and we're not going to deal with your case. So that was a lot worse for tenants than for landlords, except that sometimes the court would decide this after the case had been going on for a year and a half already, and people had been back and forth in court, and everybody's spending a lot of time and money with no resolution. And then the case gets kicked to DHCR and is sitting there for another 3 years because DHCR is slow processing anything. So it's been a big problem for everybody. So HSTPA said that, no, it's the tenant has the choice of forum. The tenant can decide the case should go to court or the case should go to DHCR. And I just saw a decision as I was writing up LVT for this month. There's a case called Streb versus Whistlepig Associates. It's in New York State Supreme Court in New York County, and it just decided, it was a case where the court had done just what I was saying, that they said, oh, we shouldn't really be deciding this. We're going to end this case, and tenant, you have to go file your complaint with DHCR. And then the Collazo decision came down, and the tenant ran back to court and said, I shouldn't have to do that. The court says now you have to decide this case, so I want you to take the case back. And the court said, you're right, we have to take the case back. So that may have some change, in terms of what's happening just with the processing of cases. So maybe that's all I'll say about rent overcharges right now. We can flip ahead to individual apartment improvements. I'm not going to say too much about this because I just want to keep us moving here. We don't have that much time. But individual apartment improvements, there was such a reduction in what's collectible for IAIs, and it's all laid out in the slides to remind you of what the criteria are now. And the one thing that I don't really know what the facts are, the buzz for a year has been that this was going to kill the construction industry, and owners were not going to be willing or able to make apartment improvements when units became vacant, as they have for a long time, because it's just not going to be affordable to do that. So how that is actually played out, I don't have the specific information about, but there certainly has been concern from the owner end that that this was going to have a grave impact on keeping apartments improved. So I think that's all I'll say about IAIs. Major capital improvements. MCIs, they're a little technical. Actually people who process the MCIs at DHCR are fairly well trained and, understand what the criteria are. There's a whole set of procedures and policies about MCIs that have been in place for years. I won't go through the details of what the HSTPA did, except it made those rent increases temporary, like it did with IAI increases. It substantially increased the amortization period, so you have to stretch out the increase that you're granted over a longer period of time. And one of the things that has happened recently, just to keep your eye on, is that the law, HSTPA said that DHCR had to establish a schedule of reasonable cost, what the cost should be of MCI. And they have just done that. They've issued operational bulletin 2020-1, which has a list of, costs assigned for different types of MCIs. And DHCR also indicated that this question of the reasonable cost will be addressed in the rent stabilization code amendments. So they are working on those. We just don't know when we're going to see them. There may be some question with the MCIs about the pending applications, and even with this now, I think I have it in the might be in the next slide, Heather. Might be even in the slide after that. Yeah, I talk about this operational bulletin, and there may be some question as to applications that were pending on June 14th, 2019. Like Regina, can you, as an owner, use the logic of the Regina case, which found it very unfair to apply something having to do with rent overcharge changes to pending cases? And there may be some argument to be made for owners that applying these cost schedules to applications that were already filed before any of this came up would be unfair. DHCR is requiring owners now to file some kind of waiver request. People who had pending MCI cases on the cost limit. So they'll have to develop the procedures, and I think what they're saying is that you're going to have, if you want to have a waiver request on the cost schedule, you have to do it within 60 days after they amend the rent stabilization code, which we're still waiting for them to do. So that might be it on major capital improvements. Okay. One of the things that the HSTPA also did that goes a little bit outside of rent stabilization, HSTPA amended the laws concerning co-op and condo conversions. So instead of requiring, say, 15% of the insiders to sign or purchase agreements before a plan could be declared effective, the amended law requires 51% of current residents to sign purchase agreements for a plan to become effective. The talk at the time this happened by people who are much more involved in co-op and condo conversions than I am was that this was going to kill condo conversions because it would make it very difficult to affect a condo conversion. And I know the Habitat group that I write these publications for and who's presenting today has a lot of publications and does a lot of webinars and Zoom meetings having to do with what's going on in condo and co-op world. So they probably have better information than I do on how HSTPA really has affected condo and co-op conversions.
Oh, that's Habitat Magazine.
What did I call it?
Oh no, that's just if you're interested in more co-op and condo information, you can look at Habitat Magazine. Okay,
right, that's right. Okay, non-payment proceedings. This is, it's funny, when HSTPA, we were waiting for HSTPA and everybody was concerned about how this was going to affect the rent stabilization law. And I don't think a lot of people quite realized that there were also a lot of changes made to the real property law and real property actions and proceedings law. That's all about what you do in housing court. And some of the changes were drastic, and some of them were not clear as to what exactly they meant or what the timing was on certain things. So there was already a lot of issues with adjusting to that. And now with, the courts being shut down for the past several months, things have just gotten, I think, more muddy in terms of getting through stuff. Non-payment proceedings. One of the things that was changed in the law concerning non-payment proceedings is you used to send a tenant a 3-day rent demand, unless your lease required more, but usually it was 3-day rent demand. You'd send them a 3-day rent demand. If the rent wasn't paid, then you could file a notice of petition and go to housing court. What you now have to do is, before you send a rent demand, you have to send an initial notice, not but with a process server, but by certified mail on a monthly basis. You send the tenant what a lot of people call the rent reminder notice. It's where, say, your average lease says, the rent is due by the 5th of the month. So after the 5th of the month, if you haven't received the rent, the landlord has to send to the tenant a letter saying, hi, it's the 6th of May and we have not received your May rent. You're late, and please let us know, if you've sent it in, or, please note that you have to send us the rent. One of the issues that came up during this COVID period, since you couldn't proceed with evictions anyway, a lot of people were holding off on sending the rent demand notices because you didn't have to send it the month the rent was due. There was a question about whether people should be sending the rent reminder notices. And some people were concerned if that would be considered harassment. But, as far as I could see, the law required those notices to go out. And in fact, during a period where there was some anticipation that there would be people not paying or being unable to pay rent, or during a period where I think a lot of people, myself included, have experienced problems with the U.S. mail, substantial problems with the U.S. mail. It's certainly earlier on in March and April. Sending that notice was a way, if you hadn't already done it, of connecting with tenants. I mean, one of the things that does seem to have gone on during this period, the pandemic period, and which the courts are constantly harping on for, attorneys to try to do if they have housing court cases, is to really try to make more of an effort to settle things, because there's just such a glut of cases sitting and pending. And certainly, by necessity or otherwise, there have been a lot of instances where tenants have advised owners, that they were having problems paying rent, or there's awareness of it. But so the rent reminder letter can be a first step to opening up that conversation. What happens after that? For a while, I think nobody was sending rent demands. One, you couldn't have a process server going out during, the real shutdown period. And two, there was an eviction moratorium put in place through June 20th. So you couldn't really start a case anyway. So the rent demand had to be sent shortly before you started the case. So it didn't make sense to be sending rent demands. And the eviction moratorium has now been extended through August 19th. And there's some back and forth about whether there's qualifications now to the eviction moratorium, because one judge had put out some kind of an order saying, no, the eviction moratorium stays in place. But there are other court directives that have come out in the past few weeks that have said that now, between June 20th and August 19th, if you're the landlord, and if you want to start an eviction proceeding based on non-payment, you have to, you do your rent demand, but when you submit your notice of petition, you have to say, kind of like a non-military affidavit, you have to say, I made an effort to find out what's going on with the tenant, and I have ascertained that the tenant is not receiving unemployment and is not financially harmed because of the COVID pandemic, and therefore I am rightfully bringing this non-payment proceeding right now. If the landlord has information, and the directives put the onus on the landlord to figure it out, if the landlord has information that the tenant is in financial straits because of the COVID situation and is having problems paying rent for that reason, the landlord is not supposed to be starting a non-payment proceeding against the tenant right now. One of the things that the housing court judges have been very good, and some of the administrative judges, with meeting with landlord-tenant attorneys through Zoom meetings and just keeping people up to date on how the court is functioning and what changes are being made and how they're going to start to provide access again, because there's a conflict there that I think a lot of thoughtful people are trying to figure out how to deal with. Is, on the one hand, if you had, before this, you would have thousands of people going through 111 Center Street to the housing court and the civil court every day, which is just not a safe thing to do at this point. And on the other hand, the courts are there to administer justice. So how do you administer? You can't administer justice on Zoom, for too long. And I think in the courts they have to use Skype. They don't use Zoom. But there are now the courts opened up during phase 2. Initially, they were indicating that you could file new petitions manually by going down to court. I've heard more things this week that they don't really want people doing that you're supposed to file things electronically. Some of the old pending cases, the judges are contacting, if the case has 2 attorneys, they're trying to process those first and, set new court dates for things, but they keep repeating that it's very slow, the adjournments will be long, nobody's getting a default judgment against anybody right now. And, what will happen with eviction warrants that were sitting for a while, or what would happen with new cases where people may be seeking evictions. They're just going to be really dragged out for a long time because the courts are so overloaded and everything is moving slow. There are certain, court officers and court personnel who are starting to be physically working in the courthouses. The judges are back working in the courthouses, but the judges, I don't think, are necessarily sitting in the courtrooms. I think, will be doing things by Skype, while they're in the courthouse, just to protect as many people as possible from COVID. So that's, and again, toward the end of the slides, I give you a few websites. The court website, there's a New York court system website that has been pretty good about keeping up to date on changes, which seem to be frequent. And Judge Fiore, who's the head judge, speaks and changes, what her little speech is periodically, so people know what's going on. And if you are either someone who works in property management or an attorney who does landlord-tenant work, it's probably a good idea to try to stay on top of that as much as you can. Check the websites a few times a week. I do that for the DHCR website too. I always did do that just to see if there are any new fact sheets or new forms or anything. And there has not been much going on with DHCR's website for a while, but I do keep checking it, and there may start to be some stuff. So it may not be a bad thing to do. Non-payment proceedings have kind of been the focus about housing court stuff during this period, because that's
holdover proceedings a bit before we move on to some questions.
I was just going to real quickly say, there's also holdover proceedings, evictions for cause. I mean, a lot of those cases have been pushed over, and there were some changes made by HSTPA that you can see summarized in the slides, but that's, non-payments seem to be everybody's focus right now. So yes, it's been 45 minutes already. Time does fly. So I haven't been paying attention. Do we have questions that have come in?
Oh, we certainly do. Let me launch right into those. Someone asked if the PowerPoints are available to download, and I believe they will be sent to you. Haya, I don't know if you want to chime in on that. We can certainly facilitate that. We'll make sure you get the PowerPoint.
Yes,
I
we
know.
will actually send it when we send the link in a few days. You will receive a survey about how your experiences were on this. There'll be a link to the recorded version, and also the Habitat Group and Eileen have kindly shared all the slides. They'll be saved as a PDF and sent. Thank you.
Okay, thank you. I know I
That
went.
was an easy question.
I went a little fast over a couple slides, so I apologize, and everyone will have access to the slides.
The slides, they don't, they're not complete, but they give you enough information to know there's an issue about something.
Yes. Okay, we have a question about individual apartment improvements. If we do not use a licensed contractor to do the work, can we still get the increase for materials without labor costs?
The increase for materials? Oh, I think, well, yes, because aren't you now required to use a licensed contractor, I think, for IAI? So, but you're saying for the cost of the question is for the cost of the materials?
Just for the material.
Offhand, I don't see why not. You still, you may have to explain how you got the materials, and that, sometimes things are clear. The idea is to be as clear and precise and broken out as you can in any documentation you have of anything. So if it's not clear on an invoice whether the price is for wood or the price is for wood, and whoever hauled the wood somewhere and did something with it, you might just want to try to have everything broken down as much as you can.
All right. Someone writes, I sent a high income, high rent deregulation application to DHCR prior to 6/14/2019. As of 6/14/2019, DHCR had not granted the order. What should I do now? Is there anything I can do?
Well, I'm surprised if you filed an HD, what they call the LD application before June 14th, 2019. Now, you don't say in the question which year it was for, but DHCR has been terminating those cases for all of them. So if you have not received an order terminating your case, I'm a little surprised. The first thing I would do is look at the docket number and go to DHCR has a web page, the case status inquiry. You can Google DHCR case status inquiry page, and it's just a little page where you plug in the docket number, and it tells you whether a case is pending. It tells you whether an order has been issued. It tells you if an appeal has been filed of that order. It doesn't tell you too much else, but it will tell you if something's happened with your case, because I would be a little surprised if an order hadn't been issued on that case.
Okay, someone asks, is that correct that you can increase a vacancy rent by the RGB percentage? Is that effective now?
It is effective now. I have had some question about it based on my reading of the language of the rent stabilization law as HSTPA amended it, but DHCR issued a fact sheet in it was a while ago. I think it was late last fall, where DHCR said that you could collect a renewal increase at the time of a vacancy. And I believe in the latest Rent Guidelines Board order that just came out last week that starts in October, it also has language to that effect that you can apply the renewal increase to a vacancy lease. I'm not sure that's what the law says. And I don't know whether DHCR, when the legislature writes the law, but then DHCR writes the rent stabilization code or amends the rent stabilization code that goes with the law. I imagine they will probably cover that in the rent stabilization code. So that might help. But I think there's a little question there right now. I mean, DHCR says you could do it. Rent Guidelines Board says you could do it. There's nothing wrong with taking the renewal increase because it's more than, nothing. Well, except if you get a 1-year renewal increase, right? Oh, no, or the first year of a 2-year renewal increase starting in October. But I don't mean to go on about that. But yeah, there's been a question, but, the powers that be are saying you can take the increase.
Okay.
So what do I know?
If a tenant breaks a lease, can we ask the tenant to pay the broker's fee?
I don't think so. You mean the broker? If you mean the broker's fee for the new tenant, I don't know if a broker's fee is considered part of the damages that can be mitigated. I think that the damages that can be mitigated are the rent, the unpaid rent for the balance of the lease. That's actually a good question. I'm not sure. I'm not sure if that's something. There may be case law on that. That may be a question if you want to. Somebody wants to put it aside, that I may be able to, to check out a little further.
Okay, in scrolling through the questions, I'm noticing that there are many related to getting the renewal increase on a vacancy. That's a big issue.
I've been asking the same question since Jack Newton Lerner seminar, I think, last year.
Yes, okay, several questions. We got a high income deregulation order issued in March 2019, but the lease does not end until February 2020. Does that mean the unit is deregulated or not?
No, that's what I was trying to talk about earlier, and having an example makes it a little easier. Those addenda orders that DHCR, explanatory addendas or whatever they were calling them, EAs, that would tend to come out after, since they would come out after the actual order deregulating an apartment because it was based on HSTPA. But no, that's what DHCR is saying, that if you get a deregulation order, but the lease, a rent stabilized lease, is still in effect on the day that happens, and the rent stabilized lease doesn't expire until sometime after June 14th, 2019, the apartment, according to DHCR's interpretation of the law, remains rent stabilized. And I just had quoted you that PAR decision where DHCR said the same thing. Now that, since they've actually, now they may have other ones, since DHCR has issued a PAR ruling on that, someone, if they want to, can take that PAR decision and go to court and challenge it. Say that this was arbitrary and unreasonable and irrational, and the court should revoke it. Whether the court will, it's not clear, because they are arguing that the deregulation law doesn't exist anymore. So you can't deregulate an apartment. But if, it might depend on when in an LD case, when was the apartment, quote unquote, lawfully deregulated? Because if you're lawfully deregulated before June 14th, 2019, you're still deregulated. So in the LD context, when are you lawfully deregulated? Are you lawfully deregulated when the DHCR's order came down, or when the lease expires? So there's probably some room to make arguments about that still. I can't predict where it'll go.
Okay. Someone says, please confirm that rent stabilized leases starting July, 1 year 0% and 2 year 1.5%. I think the new,
if you're talking about, well, you're talking about July. You're talking about right now in July. I thought I said earlier, I thought the current guidelines, and now I lost the piece of paper where I had it in front of me, I thought they were 1.5% and 2.5%. Now I could be wrong about that. I wrote down that they were 1.5% and 2.5%. And if you don't want to believe me, in case I'm wrong, you can Google New York City Rent Guidelines Board, and they provide not only the current year's guidelines, they actually have this nice summary chart that goes back to the 70s, I think, or back to the, not to date myself yet again. I mean, back in the 80s, I remember there were years where you had 17% renewal increases under rent stabilization. But you can get a summary chart of every rent stabilization increase, ever made every year.
Okay, and the ones that were just passed for next year are the leases starting October first.
First,
That's
right,
0% and then 1% on the second year of a 2-year renewal.
right. That's right.
Okay. We have a question. Someone was asking about rent control and what changes HSTPA made to rent control. Are they likely to go back to the 7% increase? I'm not exactly sure what that refers to.
Okay, the 7%, and I'm sorry, I didn't have a chance to check this before we started the webinar, because I know that the set of MVR forms for every year are on the DHCR's website, and there's a lot more than you have with other things. There's a lot of instruction forms about each 2-year cycle and what forms to use and what the percentages are. Off the top of my head, what I do remember is that the fuel cost adjustment is gone altogether. You no longer get a fuel cost adjustment under any circumstances. The 7% MCR, I think that did change, and I forget exactly how it changed. I apologize. And the other thing I'll mention about rent control, with all the talk about rent overcharges and the 4-year look back, and now it's the 6-year look back, rent control rules are very different about rent overcharges. You only go back 2 years, and you don't go file a complaint and get the same kind of order you do for a stabilized tenant that'll say, landlord, you owe and have to refund, $25,000, including treble damages. If you're a rent control tenant and you file an overcharge complaint with DHCR, you will get an order that gives you a printout of all the MVR and MCR increases that have been applied for and granted over the years. And you'll get that printout. And if the printout is not consistent with what the tenant is paying in rent, the tenant can then take that to court and get a judgment for the overcharge. It's kind of a little more complicated and convoluted proceeding for an overcharge claim, but I think historically there are far fewer overcharge complaints under rent control because that system has been so highly regulated for so much longer.
Okay, if I did an IAI or MCI prior to 6/14/19, am I exempt from the 30-year rule? No more increase after 30 years.
Yes, did you say IAIs and MCIs?
Yes.
IAIs, you should be exempt from the 30-year rule because the increase went into effect before the law changed. MCIs is different. I don't personally do a lot of MCI applications, but I know that after the HSTPA went into effect last summer, DHCR started sending owners and their attorneys and the companies that do MCI applications, they were all getting these notices where they were basically having people refile things and processing them under the new rules. Now, whether that's correct, I'm not sure, and that is something I think that some owners and their attorneys have raised as to whether it's proper to be applying the new rules to older pending cases.
Okay. Can you elaborate on the 1-month rent cap on security deposits? Is it based on preferential rent or actual rent paid? What will be the repercussions for collecting more than 1 month? Treble damages?
Okay, under rent stabilization, it's been 1 month for forever. So that's generally not so much an issue right now. And I forget there were a lot of little sub questions in there. If you're talking about an unregulated apartment, it was not unusual before the law changed to have, say, 2 months rent. Or sometimes it was not unusual, say, for example, if you had students from another country coming over and renting an apartment, and the guarantor was their family who was in another country. It was not unusual to have rent prepaid for a year. You can't do that anymore. That's considered excess security deposit. And what was the last part of that question, Heather?
Oh, well, one question, in a rent stabilized lease, do you base the security deposit on the actual rent or the preferential rent? Or can, I assume you'd want to base it on legal rent.
This will be our last
Well,
question.
Okay. I think you'd be entitled to charge the security deposit as the actual legal regulated rent. What I've seen over the years is most people tend to make it the preferential rent.
Okay, very good. Well, thank you very much, Eileen. And Haya, I'll turn it back over to you.
I'd like to second that. Thank you, Eileen. It's a lot of great information. We still have other questions, so we know we'll be following up on that. To remind you, this is just the first of 2 webinars that the Habitat Group is going to be presenting during Buildings NY Unlocked, so you'll be hearing more from us. Eileen, thank you again for all the information, and Heather for all your support and moderating this panel. Everyone, please take care and stay safe. Thank you.
Thank you.
Thank you.